On July 2, 1964, 56 years ago today, the Civil Rights Act of 1964 was signed into law. This piece of legislation marked the beginning of the nation's effort, supported by the federal government, to finally bring meaning to the 14th and 15th Amendments. It is noted as one of the most historic and sweeping pieces of legislation in our nation's history. It was signed into law by then President Lyndon B. Johnson after passing in the House in February and in the Senate in June. It was a long and hard fight to finally reach this historic point. Following the Civil War in 1868, the 14th Amendment, which granted citizenship to all persons born or naturalized in the United States, was ratified to provide African Americans equal justice under the law. Then, 2 years later in 1870, the 15th Amendment granted African American men the right to vote. While the two amendments were well-intentioned, the reality did not match them. The nearly 100 years between the ratification of the 14th and 15th Amendments and the Civil Rights Act of 1964 were fraught with segregation, oppression, extreme violence, and gross inequality. Beginning in the 1870s, Jim Crow laws were enacted and enforced. They were state and local laws that enforced racial segregation in the southern United States. They also set out to disenfranchise and remove political and economic gains made by African Americans during the Reconstruction period. These laws were enforced until 1965 in the states of the former Confederate States of America. The laws were also upheld in the 1896 Supreme Court case Plessy v. Ferguson. This case enforced the notion of separate but equal, which meant that as long as the facilities provided to each race were equal, state and local governments could still require that services be segregated. This included but was not limited to housing, movie theaters, drinking fountains, medical care, education, employment, and transportation. However, the facilities provided to African Americans were rarely equal. Most of the time they were not even close, or they did not exist at all. The legislation for the Civil Rights Act was first proposed by President John F. Kennedy in June of 1963, but was met with a filibuster in the Senate. In July of that same year, the President of the United Auto Workers, Walter Reuther, warned that if Congress failed to pass President Kennedy's Civil Rights Bill, the country would face another civil war. Following the March on Washington for Jobs and Freedom on August 28, 1963, organizers of the march visited President Kennedy and Vice President Johnson to discuss the Civil Rights Bill. President Kennedy's Civil Rights Bill included provisions to ban discrimination in public accommodations and to enable the U.S. Attorney General to join lawsuits against state governments. However, it did not include several provisions deemed essential by civil rights leaders, such as protection against police brutality, ending discrimination in private employment, or granting the Justice Department power to initiate desegregation or job discrimination lawsuits. In November of 1963, the bill was reported out of the Judiciary Committee and referred to the Rules Committee, whose chairman was Howard W. Smith, a Democrat and staunch segregationist from Virginia, who intended to keep the bill bottled up indefinitely. After President Kennedy was assassinated in November of '63, his successor, President Lyndon B. Johnson, continued to push the bill. In his first address to Congress on his fifth day as president, he told legislators no memorial or eulogy could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill, for which he fought so long. A coalition of 70 liberal and labor organizations known as the Leadership Conference on Civil Rights coordinated the lobbying support for the Civil Rights Act. The key lobbyists for the Leadership Conference were civil rights lawyer Joseph L. Rowe, Jr. and Clarence Mitchell, Jr. of the NAACP. President Johnson wanted the bill passed as soon as possible and ensured that it would be quickly considered by the Senate. Normally, the bill would have been referred to the Senate Judiciary Committee, which, at the time, was chaired by Senator James O. Eastland. Senator Eastland, a Democrat from Mississippi, was firmly opposed to the bill, and thus it seemed impossible the bill would ever reach the Senate floor. However, Senate Majority Leader Mike Mansfield saved the bill from being relegated to Judiciary Committee limbo. After a second reading of the bill in February of '64, Senator Mansfield proposed that the bill bypass the Judiciary Committee and immediately be sent to the Senate floor for debate. The bill came before the full Senate in March of '64. It was during this debate that the Reverend Martin Luther King Jr. and Malcolm X briefly met for the first and last time. Also during this debate, the bill was met by a filibuster launched by 18 Southern Democrats and one Republican senator, who were known as the Southern Bloc. They were led by Richard Russell, the Democratic senator from Georgia. Immense opposition also came to the bill by way of Senator Strom Thurmond, a Democrat from South Carolina. Senator Thurmond called the Civil Rights Bill unconstitutional, unnecessary, unwise, and beyond the realm of reason. After 54 days of filibuster, Senators Hubert Humphrey, Mike Mansfield, Thomas Kuchel, and Everett Dirksen, 2 Democrats and 2 Republicans, introduced a substitute bill they thought would help end the filibuster. Their proposed bill was weaker than the one in the House, but was still substantial enough not to cause the House to reconsider the legislation. The filibuster ended with a vote of 71 to 29. On June 19th, the substitute bill passed the Senate with a vote of 73 to 27. The bill passed quickly through the House-Senate Conference Committee, which adopted the Senate version. Both houses of Congress then passed the bill, and the Civil Rights Act was signed into law by President Johnson. Overall, the Civil Rights Act of 1964 outlawed discrimination based on race, color, religion, sex, or national origin. It prohibited unequal application of voter registration requirements, as well as racial segregation in schools, employment, and public accommodations. It was just recently amended to say that discrimination on the basis of sex also applies to the discrimination of sexual orientation and gender identity. We have several books on the civil rights movement, especially regarding the Civil Rights Act of 1964, here in the Lenski department. Call or go online to reserve yours today.